Good afternoon, distinguished ladies and gentlemen. Thank you for your kind invitation to speak before you today, while you discuss an important topic for Ireland, the EU, and humanity. My name is Munir Nuseibah. I'm a professor of international law and the founder and head of the Human Rights Clinic at Al-Quds University in Palestine. In my oral statement before you, I will provide my legal opinion and advice on the matter under examination by your distinguished committee, by taking into consideration the most recent developments and discussions. In a recent questioning before the TDs, Mr. Gabriel Makhlouf, the governor of the central bank, stated, quote, "We have to operate within the rules that have been set before us. So in this particular case, the rules make no reference to the Genocide Convention. So we can't take it into account." This statement demonstrates a gap between actions and international obligations. It also highlights a legal issue that has been resolved in international law, namely the hierarchy of international legal obligations. Furthermore, it raises the question of the status of Ireland's obligations as an independent and sovereign state, while being a member of the European Union and other international organizations. My statement will focus on these points. First point, if and when international legal obligations conflict, what do we do? International law stems from customs, treaties, and other sources. Of course, each agreement a state authors or joins is designed to serve its interests and reflect its principles. But in some situations, like the one potentially highlighted by Mr. Makhlouf, legal obligations conflict. International law obligations are not all equal, and there are cases where the choice is clear. At the top of the pyramid of principles in international law are jus cogens norms, also known as peremptory norms of international law. Such norms are the ones that the international community understands and recognizes as binding to all states, without any derogations. They stem from customary international law and treaty law. Examples of this type of norm include prevention of genocide, torture, forcible displacement, and other international crimes. They also include the right to self-determination. The actions and words of the central bank's governor demonstrate that he prioritizes what he sees as Ireland's obligations according to EU law, and argues that the EU and the UN should look into measures against Israel. Authorizing the sale of bonds contributes into Israel's genocide operations, colonization in the occupied Palestinian territory, its long-standing denial of the right of the Palestinian people to exercise their right to self-determination. Even if EU agreements allow, or as argued, oblige Ireland to authorize the sale, the higher obligation of the Irish state is to prevent genocide, war crimes, and crimes against humanity. The International Court of Justice, in its advisory opinion in July 2024, stated that all states, every state around the world, all states are under an obligation not to recognize as legal the situation arising from the unlawful presence of the State of Israel in the occupied Palestinian territory, and not to render aid or assistance in maintaining the situation created by the continued presence of Israel, of the State of Israel in the occupied Palestinian territory. So this is an order for all states. Second point, my second argument. Ireland is an independent state with full responsibility for the actions of its organs. It has been argued in the same context that it is the responsibility of the EU or the UN to address questions of genocide and other crimes, not the central bank or Ireland on its own. Some also argued that Ireland's contribution to ending the genocide must be exclusive to diplomatic means. This argument has no foundations in international law. Ireland is an independent, sovereign country with full personality in international law. It's not a region within a federation. The EU itself does not erase the independence, hence the responsibility of each state within the Union. Also, a state may not act in a way that contradicts with its obligations, even if it struggles against violations in diplomatic circles. As a sovereign independent state, the Republic of Ireland bears the responsibility of all of its organs if an illegal action stems from its government, judiciary, legislators, or other organs, such as the Central Bank of Ireland. Ireland is, in that case, Ireland will be held liable. Article 27 of the Vienna Convention of the Law of Treaties states, a party may not invoke provisions of its internal law as a justification for its failure to perform a treaty. Similarly, Article 3 of the Codified International Legal Reference on the responsibility of states for internationally wrongful acts stipulates the characterization of an act of a state as internationally wrongful is governed by international law. Such characterization is not affected by the characterization of the same act as lawful by internal law. Article 4 of the same law reads, the conduct of any state organ shall be considered an act of that state under international law, whether the organ exercises legislative, executive, judicial, or any other function. Whatever position it holds in the organization of the state and whatever its character as an organ of the central government or of a territorial unit within the state. An organ includes any person or entity which has that status in accordance with the internal law of a state. End of quote. Hence, it's the responsibility of Ireland to reform its due diligence procedures and legal system in a way that prevents the violation of its international legal obligations. From the eyes of international law, any violation of Ireland to preemptory norms of international law can bring about state liability, as well as individual criminal responsibility for individuals who contribute personally to the criminal act, including by facilitating the funding of an apartheid regime that is using its budget for genocide, ethnic cleansing, continued colonization, torture, and degrading treatment, and many other atrocities. In conclusion, I recommend that the Republic of Ireland should immediately act to stop its role in the authorization of Israeli bonds. Furthermore, it should reform the system that allows for a continued Irish role. This is based on, first, Israel is committing international crimes, including but not limited to genocide. The International Court of Justice has already declared the Israeli occupation as illegal and as a regime of apartheid and/or racial segregation in its advisory opinion in 2024. The bonds are financing these crimes. Second, even if Ireland has legal obligations stemming from its membership in the European Union, these obligations must not contradict with preemptory norms of international law, which include genocide, apartheid, forcible displacement, and many other crimes. Ireland is an independent state and must not assume that its membership in the EU or the independence of the central bank will prevent its own liability for aiding genocide and other crimes. Finally, aiding international crimes also invokes individual criminal responsibility, in addition to state responsibility. Ireland has incorporated the provisions of the Rome Statute into its domestic criminal code. Hence, aiding international crimes also has risks for officials in the central bank. Thank you very much.